Hi, my name is Shohini Bagchee, and I'm a senior patent agent at Field Law. In today's episode of IP Explained, we're going to talk about Patents 101. There are many forms of intellectual property, and if you'd like to learn more about them, please check out my colleague Laura McFarlane's episode called The Basics. Patents are used to protect inventions, and inventions can be defined as a technical solution to a technical problem. You may wonder, is my invention patentable? Well, there are three basic criteria to meet to patent your invention. The first is that your invention must be new, meaning it mustn't be disclosed anywhere in the world prior to filing for patent protection. The second is that your invention should not be obvious to a person of skill in that art or technology area prior to filing for patent protection, or in view of more than one reference that were made public before you filed for patent protection. And finally, the subject matter of your invention must be considered patentable. Patentable inventions are considered to be compositions, devices, systems, and methods, again, that solve a technical problem. To determine if your invention is indeed patentable, we recommend getting a patentability search conducted. The results of a patentability search will let you see the technology that's come before your invention and give us a sense of if your invention is significantly different enough to potentially be patented. If we determine that your invention is likely patentable, your patent agent will prepare and file a patent application for you, which will then be examined at the patent office. After the examination process, your application is allowed and you have a granted patent. It typically takes about 2 to 5 years from filing for patent protection to getting a granted patent. Your granted patent gives you a monopoly of about 20 years of protection of your invention. Patents are granted on a country-by-country basis. So a Canadian patent will protect your invention in Canada, but it will not protect against, for example, infringing activity about your technology in the United States, for which you would need a U.S. patent. Patents are different from trade secrets in that patents are published and they give you, as I said, a limited monopoly for about 20 years. By contrast, trade secrets are never published and they can give you protection for as long as you can maintain the confidential information as a secret. If trade secret information is disclosed, there's less recourse than in the case of a patent. If I can leave you with 3 important lessons about patent protection, this is what they are. Firstly, it's very important that you do not disclose your invention before you file for patent protection in at least one country. Secondly, the patent system operates on a first-to-file basis, so you want to file for patent protection as soon as you possibly can. And lastly, patent ownership begins with the inventors, those who created the technical solution to the technical problem. From there, patent rights can be transferred and bought and sold just like any other form of property. For more information on IP ownership, you should check out my colleague Richard Stobie's episode entitled, Who Owns a Company's IP? If you have more questions about patents, or if you think you would like to seek out patent protection for your invention, be in touch with patent agents and lawyers at Field Law. We'd be happy to help.